Hi, my name's Claire Harrison. I'm the founder and managing director of Harrison Human Resources. At the moment, we're getting asked lots of questions about how do I reduce my employee costs, my staff costs. There are really three main areas to do this. One, negotiating new terms and conditions of employment. So that might be negotiating with your employees a change of hours, a reduction in hours, or a reduction in pay rate, or taking of leave, annual leave, or on a partial basis or not, or even taking long service leave or taking some unpaid leave. But it's really important to remember that even though we're in difficult times, you still do need to comply with the Fair Work Act, the modern awards that apply to your business, or any enterprise agreements or the employment contracts. The second group of options available to you only apply to those employers that are eligible for JobKeeper. So if you are eligible for JobKeeper, there's a number of other provisions and options available to you. So they include directions for stand down, partial stand down, change of work, change of duties, and change of work location, as well as some other options available to you as well. There have also been changes to about 99 modern awards, and that is around 2 weeks, a one-off, 2 weeks taking of unpaid pandemic leave, which applies to people that need to be isolated, but not because they're ill. And the second one is to be able to take half pay annual leave at double the amount of time. And the worst case scenario is obviously if you expect that your business will be downturned for a significant amount of time, possibly you're not eligible for JobKeeper, there is the option of redundancies, but that is a worst case scenario. So really, the three areas are those negotiated changes to terms and conditions. Secondly, are the JobKeeper provisions, which I'll talk more about later on. And thirdly is redundancy. Just keeping in mind that if you are paying redundancy, you still do need to pay severance payment, notice of termination, etc. The question we get asked is, how can I use the JobKeeper provisions to reduce my employee costs? So in this video, I'm going to talk specifically about the JobKeeper enabling provisions that are available for those employers that are eligible for JobKeeper. So importantly, these options do only apply to those employees eligible for JobKeeper. So if you're unsure about if you are eligible or not, you should check with your accountant or talk to Yield Advisory. So the JobKeeper provisions, there's 5 different areas. So there's a stand down of employees, or it could be a partial stand down, which is a reduction in hours of work. Secondly, there's a change to an employee's usual duties. So they could do something else, which I'll talk about more later on. Or there's a change in employee's location of work, such as working from home or working from one of your other offices. There is also a request and agreement with employees to take annual leave, which is different from what we have at the moment in our modern awards. And there's also a request and agreement to change days and hours of work, not reduce, but to change days and hours of work. So again, importantly, with all of these conditions, you cannot reduce someone's hourly rate of pay. That's a requirement under these JobKeeper enabling directions. Or the agreements is you must continue to be paid their same hourly rate they have been previously. A qualifying employer is only allowed to make JobKeeper enabling directions or agreements under these new provisions for the duration that they're actually receiving JobKeeper. So if you're not receiving JobKeeper for the full 6 months, you can only apply it for the period that you're actually receiving JobKeeper or eligible for JobKeeper. An employer should confirm that you're entitled to JobKeeper, like I said, before you apply these provisions, which can be done with help from your accountant or from Yield Advisory. So this is a direction to reduce the days or work hours of an employee. So you can either stand them down full-time or you could stand them down part-time, which is different to what is currently contained in the Fair Work Act. So a JobKeeper enabling stand-down direction enables an employer to direct an employee to not work on certain days, or to work for a lesser period, or to work for a reduced number of hours. So an employer, importantly, can only give a JobKeeper enabling stand-down direction if the employee cannot be usefully employed for their normal days or hours of work because of changes in the business that are attributable to either the coronavirus pandemic or a government initiative to slow down the spread of coronavirus. So that's really important. It needs to be related to those things, not just a general downturn in your business. So it's different from the stoppage of work test that's currently contained in the Fair Work Act. So that's been put aside for now. Instead, there needs to be a no useful work requirement for the employee. So that means they cannot be usefully employed by you. So to use the stand down direction, an employer importantly needs to continue to meet their safety and duty of care requirements as they have previously. They must be entitled to JobKeeper. So if you're unsure about that, you should talk to your accountant or to Yield Advisory. And an employer needs to make sure that the direction isn't unreasonable. So that will be taking into account things like carer responsibilities. So if the direction is unreasonable, then it will not apply to the employee. So stand down directions do not apply to employees on approved paid or unpaid leave, but JobKeeper payments will apply to those people. Employees subject to JobKeeper enabling stand down directions still accrue their usual leave entitlements for the period that the direction applies. And with an employee when an employee is subject to JobKeeper enabling stand down, the employer must pay them either the JobKeeper payment or their usual pay for any hours that the employee does work, whichever is higher. Importantly, again, as I mentioned in an earlier video, the hourly rate guarantee applies. So you cannot reduce the employee's normal hourly rate of pay. Very important. A JobKeeper enabling stand down direction must be in writing, and there's a definite need to consult on all three of the directions under the JobKeeper enabling provisions. So that means that you need to notify the employee and consult with the employee and their representatives, if applicable, at least 3 days before issuing the direction, unless the employee agrees to a shorter period of notice, but it does need to be agreed. And you need to keep a written record of that consultation requirement. So that's a little bit more information about the JobKeeper enabling stand down provision. So the JobKeeper enabled change of duties and location directions have similar requirements to the stand down direction in that employers must qualify for JobKeeper. They need to meet the wage requirement of paying employees at minimum $1,500 per fortnight. They need to meet that safety obligation, that continual duty of care for their employees. There needs to be a reasonableness of the direction. And there's that hourly rate guarantee, and that is that you cannot reduce an employee's normal hourly rate of pay. In addition to that, for the change of duties direction, it must be within the competency and skills, including any required licenses and qualifications of the job for the person. Second to that is the duties are reasonably within the scope of normal business operations, which means you couldn't get your accountant mowing your lawn at home because that would be outside the scope of the normal business operations. For the change of location, which is really set up for the working from home direction or directing employees to work from a different one of your work locations. For that one, again, you need to meet that reasonableness within the scope of the business activities that you would normally be undertaking. As well, it needs to be a suitable location where they can actually do their work. Importantly, I think it's worth considering that you don't actually need JobKeeper to direct people to work from a different location, such as working from home, given the current situation with coronavirus. As well, there is an extra safeguard for JobKeeper enabling directions about duties and locations, which is that the employer has to have factual information in front of them that leads them to reasonably believe the direction is necessary to maintain the employment of the employee or employees. That is, if it wasn't for the direction, that the employee or employees would not have a job. So that's an additional consideration for these two directions. And again, there is the requirement for consultation, similar to the stand down provision. So you do need to show a record of consultation. So at least 3 days before, you need to consult with employees on the change of location or change of duties. And 3 days before the direction, then you can provide the direction and just keep a record of consultation in your documents. So really important, that consultation requirements. So what are the other provisions available to JobKeeper eligible employers, in addition to the 3 directions that we've spoken about on the earlier videos? So they are, and they request an agreement rather than directions like the other 3 that we've spoken about. So there are 2 for JobKeeper eligible employers, and they are the request an agreement to work different days and times, not reducing hours because that would fall under the stand down direction. And there's also the request an agreement to take annual leave. So qualifying employers, and again, if you're unsure about whether you qualify or not for JobKeeper, you should check with your accountant or with Yield Advisory. But qualifying employers are able to request and agree with an eligible employee, being a JobKeeper eligible employee, that they will perform their usual duties on different days or times than usual. The employer needs to make sure that the change is safe and the employee's usual hours and work aren't reduced. So we're not reducing hours of work. Reducing hours requires, as I mentioned, the use of the JobKeeper enabling stand down direction. So in regards to the request to take annual leave, so it's a new provision for qualifying JobKeeper employers, and that is to request eligible employees, being JobKeeper eligible employees, to take a period of annual leave, keeping a minimum of a 2-week balance of annual leave. They agree in writing with an employee to take the leave at half pay is also an option for twice as long. So they're the 2 parts. One is the taking of the annual leave, and there's the option to take it at half pay. So the employees on half pay still accrue leave in their usual leave basis, and any redundancy or payment in lieu of notice of termination is at their normal rate of pay, importantly. Employees cannot unreasonably refuse the employer request to take annual leave. So that's different from the normal provisions. However, some existing awards may make it easier for you to use this provision of directing to take of annual leave, because some will have directions or different minimum entitlements for you to be able to force people to take annual leave. And also just remember that award-free employees don't actually have a minimum annual leave balance that needs to be maintained, but you would need to agree with them on that. So that's the additional 2 provisions, which are around the taking of annual leave and the varying the hours of work for JobKeeper eligible employers. So really what we talk to employers about is having a really clear communication strategy. So going out to all of your employees to explain the situation that you're currently in. So that's a financial situation, the challenges that are being faced, so they understand the big picture, you know, and if we don't make some changes, there may not be a business, we may not have jobs. So let's all get together and talk about, I suppose, some short-term sacrifices that we can make. So I think it's important to set that you know, strategic picture so that everyone understands that we're all going to make sacrifices for the long term, for our long-term jobs as well as that of the business. So it's about that communication. And then really, because if you're not eligible for JobKeeper, you can't go out and direct employees to change pay rates or whatever else. So it's really about a negotiation. So that's about talking to employees about what you're looking for. So if that is a decrease in pay rates or decrease in hours of work, taking annual leave or unpaid leave, then you need to have those discussions with employees. And then I think it's important to ensure that they know they're temporary arrangements, they're not permanent arrangements. You do need to meet any award, Fair Work Act, enterprise agreement or employment contract requirements or obligations that you currently have in place. So just because we're going through difficult times, it doesn't mean that you don't have to do that. So that still means you need to pay penalty rates if you're working Sundays normally, or if you're paying overtime rates for working long hours, then they still do need to be paid. So importantly, any change or temporary changes to terms and conditions of employment should be documented and have clear dates for when they will be reviewed and the transition back to normal, which I think leading on to that is an important consideration. So creating some milestones. So whether or not it's when you get back to a certain revenue or a number of clients or a number of product, whatever it might be, that employees' pay rate or hours start to go back to normal, so that employees understand there's a really clear milestone that has to be achieved by the business for us to return to our normal rates of pay, and they don't just see it as being an indefinite reduction that's being made to their terms and conditions of employment. So there's some thoughts about how you would approach employees about reducing your employee costs. Thank you.